We'll go ahead and call the meeting to order. Before we do the roll, I'd like to make a point of welcoming our newest addition to the commission, Commissioner Tony Parikh.
Thanks, sir.
Call the roll.
Brian Crawford.
Here.
Mark Cole. Monty Matalago.
Here.
Vernell Neville.
Here.
Tony Parikh.
Here.
Eula Simeon.
Here.
Jared Ricky.
Here.
Lenore Feeney. Here. Jason Hanneman.
Here.
And Erica Dorsey.
Here.
I'd like to observe a moment of silence, please.
Allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Had any requests to address the commission on matters on the agenda?
We have not, Mr. Chairman.
We will move on to the business items on the agenda. Item number one is consideration of the meeting minutes from August 10, 2023. Do we have a motion?
Move to accept as presented. And second.
Moved and seconded. Any discussion? All in favor?
Aye.
Any opposed? Next item on the agenda is in the matter of Russell Graham, Department of Public Safety and Corrections, Office of State Police, docket number 22264S. Mary White is representing Mr. Graham, and Gail Holland and Tunde Anes Mason represents the Office of State Police. We had a public hearing that concluded on August the 10th. The executive session discussed investigative proceedings regarding allegations of misconduct was deferred at that time. So I'd entertain a motion to go into executive session to discuss the allegations of misconduct.
So move.
Been moved and seconded. Take a roll call vote, please.
Brian Crawford.
Yes.
Mark Cole.
Yes.
Monty Matalago.
Yes.
Vernell Neville.
Yes.
Jared Ricky.
Yes.
And Eula Simeon.
Yes, we will make note of the fact that Commissioner Crawford was not present last time. And I understand intends to not participate in the discussions, as well as Commissioner Parikh, who just joined us, thankfully joined us this morning. So it's been moved, seconded, and voted on. So we're going to go into executive session as is customary. Take all your belongings with you. Don't wait in the area out here. Go out into the atrium area. Okay, we'll entertain a motion to come back into public session.
I'll move.
Been
Second.
moved and second, and take a roll call vote, please.
Give me one second. Jared Ricky,
Yes.
Mark Cole,
Yes.
Monty Montalvo,
Yes.
Vernell Neville,
Yes.
Eunice Simeon.
Yes,
We're doing the roll call just for the decision or just the roll call to come back in?
this was the
Come
roll
back
call.
in.
Come back in.
Okay, Tony Pari,
Here.
alrighty, that's it. And Brian Crawford.
Yes.
Do you have any motions?
I'd like to make a motion. I'd like to move that we grant the appeal, that we rescind all of the disciplinary actions, that we expunge the record, that back wages be paid, reasonable attorney fees with a maximum of $1,500, and reimbursement for any non-employee witness fees in accordance with the 19 JDC guidelines.
Do we have a second to the motion?
Second.
It's been moved and second. Any discussion? Call for a vote.
Right, and Jared Ricky,
Yes.
Mark Cole,
Yes.
Monty Montalvo,
Yes.
Vernell Neville,
Opposed.
and Eunice Simeon.
He's the chairman. He doesn't have to vote unless it's a tie.
But
No.
I mean, I'm just saying.
yeah. I'm going to vote in favor of the motion. Though I do have some concerns about the activity, but I didn't hear the evidence that would support the concern that I have about that activity. And so based on that, I will vote in favor of the motion.
Thank you.
What's that? All right, so is that everybody?
Yes.
Okay, motion carries. The next matter on the agenda is oral arguments on pre-hearing motion filed in the matter of Kasha Domain, Department of Public Safety and Corrections, Office of State Police, docket number 21250. Ms. Domain. Ms. Domain is here present representing herself, and the department is represented, and the Colonel is also present. Please announce your presence, please.
Good morning, Mr. Chairman, and good morning, Mr. Commissioners. My name is Tunde Animashao, and I represent the Louisiana Department of Public Safety, Office of the State Police in this motion.
So Tunde, you did notice I tried to get it out this morning.
Yes, sir, you did it.
I came kind of close.
I think you did a good job, sir. I'm not gonna, sorry.
All right,
We are the mover for this motion, and we would like to proceed. I have a lot of copies of the exhibits that already filed, but if you need additional one, I could.
You all have.
we have been provided with.
Oh,
exhibits
I just
already.
wanna make
Thank you for coming prepared to do that, but we have the. exhibit.
Yeah, I have extra copies. All right. The first thing I wanted to say to the commissioner is that the appellant did not file a reply memorandum or opposition to this pre-hearing motion that is due on September 7, 2023 in accordance with the pre-hearing conference order. Secondly, and most importantly, this appeal in its current state is defective. It's defective because the relief that was requested by the appellant had already been granted, and this appeal is moot. In other words, there is no clear or a specific legal right to be enforced or a duty that ought to be performed based upon the current appeal. And the reason for that is this: the appeal does not state the current state of cause of actions for which a relief ought to be granted under the State Police Commission Rule 13.2G. If we look at the State Police Commission Rule 13.2G, which require requests for appeal, it requires that a notice of appeal must be in writing. And also it must state, the G clause said, it must state the relief the appellant seek. The fact of this case are not in dispute, Mr. Commissioner. The reason being that on July 10, 2018, while employed as the Louisiana State Police trooper, former trooper Kasha Dome discharged a department-issued firearms and inflicted serious bodily injury on Clifton Scardelli. If you look at the Exhibit A that is attached to the motion, you will find that on October 10, 2020, an East Baton Rouge Parish grand jury returned an indictment under the docket number 20-04787 of the 19th Judicial District Court that formally charged the appellant with 2 felonious offenses, which are aggravated second-degree battery, which is a violation of revised statute RS:1434.7, as well as illegal use of weapon or danger instrumentality, which is a violation of Louisiana revised statute 14:94B, which is Exhibit A. On March 11, 2021, the appellant was terminated from her position as a Louisiana State Trooper effective March 16, 2021, for violations of several of the LSC policies, which include the use of firearm, body-worn camera, conformance to laws, unsatisfactory performance, and conduct unbecoming an officer.
So why is it that you say that her appeal has not stated a claim for relief which can be granted?
Because if you looked at her appeal, that's a good question. If you look at our appeal, which is Exhibit E, and if you look, it's not numbered. If you look on the last column before our signature, and let me read it to you. This is the request. He said, I respectfully request that my appeal process to be placed in a state of stay from this time until the conclusion of my criminal and civil trial, as there are confidentiality agreement regarding release of information in place. That was the prayer for relief. As a result of
No
that,
other prayer for relief?
no, sir,
Has it ever been amended?
it has never been amended since 221. This appeal was filed by Ms. Kasha Dome and was received by the State Police Commission on April of 2021. It has not,
Was it filed by her without a lawyer?
it was filed improper person, that's correct.
Okay.
It was filed improper person and it was received by the State Police Commissioner April the 12th, 2021.
Give me 1 second, please.
Okay.
Makes a statement, does it not?
Yes, it does.
And would you read that to the record as well?
He said, please accept this letter as my formal appeal to the termination of employment by Louisiana State Police.
Okay.
He said, in reviewing State Police Commission Rule 12.2, then
So she obviously made it clear in the first statement in her appeal that she wanted to appeal her termination. I understand the reading of the prayer, but you're dealing with a pro se a litigant who's not represented by a lawyer.
She has an opportunity to be represented by a lawyer.
Well, we're not in a position, particularly in a summary disposition, to resolve that issue. There might be many reasons why she wasn't represented by a lawyer. I don't know, but the appeal does at least state that she is appealing her termination, correct? It's not I understand it's not formally stated in the prayer, but the appeal does state that's what she's.
But according to your rules, Rule 13.
That's a yes or no response.
Yes.
All right, thank you.
But according to your rule 13.2, request for appeal, it said a notice of appeal must, doesn't give may, doesn't say, it's a must. And rule of construction of legal term must means it shall be done. That's what's the rule of construction.
And it's up to this commission to decide whether we could read that in the first paragraph, the middle paragraph, or the last paragraph, right?
That's correct, Mr. Chairman.
All right, you
But
may proceed.
that's not the only defective. That is not the only defective issues with this appeal.
Okay, what else we got?
Because in our appeal, she indicated that with regard to the termination letter that you just mentioned, she indicated that there may be some issues of discrimination. But if you look at your rule, 13.2 request for appeal, especially this.
Thank you.
Especially the D clause, D5, because in order for us to prepare a defense for what she's alleging, especially D5, it said as a description of events, including the dates and circumstances thereof, which led applicant to believe that the adverse action here, gentlemen, is determination, was based on religion, political belief, sex, race, or any non-merit. And the reason was given that has to be stated. The reason being that it has to provide us with a sufficient detail to enable the agency to prepare a defense. That is not done in this case. That is also a deficiency in the appeal.
Okay. Are you seeking a dismissal of that particular allegation, or are you seeking the dismissal of the entire appeal because your position is that particular allegation does not have enough detail?
This cannot be cured, Mr. Chairman, because—
Well, I didn't ask if it be cured. Let's assume it can't be cured. My question to you is, are you seeking a dismissal of the entire appeal because it is the state police's position that a single basis for the claim, discrimination, has not been adequately pled, or are you only seeking a summary disposition on that one issue as to whether or not at whatever hearing we may or may not have, we would accept any evidence on the discrimination claim?
In addition to that, I'm seeking dismissal on that plus more, because as I'm going to explain to the commission, that is a defect in that appeal, because we have to be placed on notice. What is the basis? Actually, reading the State Police Commission rule, I like the word he used, sufficient detail, not just because he said a conclusion of discrimination is not sufficient, and that is 13.2D, the last sentence in that paragraph. It stated that a conclusion of discrimination is not sufficient. And it states in item 5 that in all notices of appeal, specific facts supporting the conclusion that a violation of discrimination, either based on religion, political belief, sex, race, or any other non-merit, he said must be alleged in sufficient detail to enable the agency to prepare a defense.
But if I were to agree with you that and I'm not saying I do or I don't, but if I were to agree with you that that is not an adequate allegation of discrimination to substantiate an appeal on this claim of discrimination, why does that eliminate the other claims that have been adequately alleged?
Because the reason for that is very clear, Mr. Chairman, because on April 12, 2021, the appellant was granted a stay pending the resolution of the criminal matters. And that was a judgment that was signed, that is Exhibit E. And that was, Exhibit F. Thank you. And that was signed by the Executive Director of the State Police Commission, which order was granted the motion to stay. That order, if I can, and I know you have a copy, not to bother you, but it's clearly stated that the proceeding, which was the prayer, was stayed pending the dismissal of all criminal charges. Based on the facts in this proceeding, whether it's a plea of guilty or no contest by Ms. Dominic to any criminal charge based on the facts in this proceeding. And that was signed on April the 30th.
And we have now lifted that stay because
The criminal proceeding has been concluded.
the criminal proceeding has been concluded. We have lifted that stay. So I'm trying to figure out the relevance of the order that was granting the stay. I mean, we've lifted the stay now. We're ready to proceed, but you're asking us, just because the stay is lifted doesn't mean we will automatically dismiss her appeal, or we will dismiss it on summary disposition unless there are no disputed facts upon which the state police can establish that is entitled to a ruling in its favor.
Yes,
So-
yes, Mr. Chairman. Moving forward to that, to answer their question specifically, when you look at Exhibit A, which is very, very important here, when you look at Exhibit A, because on September 12, 2022, the appellant pled guilty to the amended misdemeanor.
Correct.
In that plea, this is her statement, and I'll read it. Here you go. In Exhibit A, he said, to whom it may concern, and this is signed by Ms. Kasha Dome. Please accept this letter as official notification that I, Kasha Dome, white female, date of birth, 1977, do hereby, this is the operative word, voluntarily, immediately, and irrevocably
She's
surrender.
irrevocably given up her post qualifications. We're well aware of that.
Okay,
As of what date?
as sort of, I believe 2022.
Okay.
I mean, as of, that's Exhibit C. So,
Thanks.
so she gave it up on 9/22/2022 because she received a letter of post, which she voluntarily did that, and that's Exhibit C.
Okay.
So there is no, that's the point, Mr. Chairman. That is no current legal basis upon which this appeal should proceed. Because she has already, the appeal is moot.
Well, would you not agree with me that there was a period of time between her termination and her surrender of her post qualifications?
That's correct, because the criminal proceeding was still on.
Right. But regardless, if she got fired on September 29th of 2022, and you came to me and said, I want a summary disposition because she just got fired, she doesn't have post credentials, I would have to tell you, well, I think there's no disputed facts here. You certainly were entitled to fire her because she didn't have post credentials, but this firing wasn't based on her not having post credentials. This firing was based on another act, the facts of which I think might arguably still be in dispute. And so though she cannot be reinstated to her employment today, we certainly, and I'm not making a determination of what we would find, but we could find under the facts that her termination was not appropriate, and therefore she was entitled to her employment up until September 29th of 2022. Could we not?
Well, you could.
Well, then how does her surrender of her post credentials render the appeal moot?
Because during the sentencing before the 19 JDC, she clearly expressed to the court that she didn't want to be a law enforcement officer. In other words, so she acquiesced into the termination.
But she didn't want to be a law enforcement officer from that date forward. It doesn't mean she was voluntarily relinquishing her claim to her entitlement to be a law enforcement officer up until that point.
But that's my reading of the if you look at the exhibit B, the Boykin examination and sentencing, which is on page 14,
Okay.
which is very, very clear that what she stated to the court, which was accepted by Judge.
Read the part that tells me she was voluntarily relinquishing her claim that prior to that date, she was entitled to be a police officer.
No, she said future employment.
Future.
I mean, yeah, future employment. You are
Okay.
correct on that.
All right.
Future
And
employment.
this is not, these questions have nothing to do with what we might decide once we hear the evidence as to what happened. Because I haven't heard it yet. I can't prejudge it. But you're asking us to rule as a matter of law, in essence, that she doesn't have a claim, but up until September 29th of 2022, whether it's a meritorious claim or not, we get to later, she still has certain rights that she could still ask this commission to reinstate, and that is her back pay up until that time, set aside her termination based on the reasons for her termination at the time they were given. Now, if y'all were to fire on September 29th, I'd have to agree with you. Summary disposition in a heartbeat. But I'm having a hard time, and I'm not saying you're wrong, but I'm having a hard time seeing summary disposition.
Well, as a lawyer, we could argue for our clients, but I'm looking at it, objectively, because it's a future employment, and I admitted that because that's what Judge Tiffany Foxworth indicated in the sentencing.
Right.
But the key question right here, Mr. Chairman, is this issue right here. The surrender of the post actually render her claim to be ineffective because she cannot be a law enforcement unless she's post certified.
From September 29th,
That's correct.
2022 forward. I got no reason to disagree with you on that part.
But also we have to understand that the decision of the agency was based on policy violations.
Which we have to determine at a hearing.
Okay.
Right? I mean, we cannot, unless everybody was to get up here and say there are no disputed facts on what happened in this incident. And as a matter of law, she violated it, then you could do summary disposition. But when there are, I take it, she's disputing some of the facts upon which the termination was based, how can we grant a summary disposition? We might ultimately grant and find that the department correctly terminated her, and I'm not making a decision on that. I'm just hypothetically speaking. But while the facts are in dispute, we can't make that determination, and we can't base it on her post surrender because that didn't happen until later.
But also, Mr. Chairman, there's never been any response from Ms. Keshado.
She didn't file an opposition.
So I mean,
I understand that.
So there's no opposition to that. So this is our time to.
But we still have a duty as a commission to follow, whether she had a lawyer, didn't have a lawyer, did or didn't file an opposition. We as a commission have to decide this properly under the law, and we have to evaluate it. And that's why my questions are to you as to how it is the post surrender can affect her rights, that are potential rights that may have predated the surrender of her posts. And I'm being as blunt as I can. I'm not seeing it unless you can help me see that.
That might be for trial.
And that's why I'm having a hard time seeing summary disposition. Okay, thank you. Is there anything else?
That's all I have right now.
Ms. Domain, do you have any?
Yes, sir. When it comes to the post certification, I was hired as, I would imagine 90% of those students coming in as cadets are hired without a post certification. Also, all WAEs that return to duty. So the fact that I could return with the post certification, I do not choose to be a Louisiana State Trooper moving forward. So as you said, for future employment, I would like to leave state police in good standing. I have continued to serve my community and my country. I was a United States Marine. I started a nonprofit youth organization for underprivileged children in Lafayette. I got a,
But suffice it to say, for these purposes, it is still your desire to proceed with this appeal,
yes, sir.
even though after September 29 of 2022, you would not have been eligible for employment with state police.
I think there would have been some time. I think there's some time after you're hired that you do have time to then get your post certification is what I'm saying.
But you irrevocably surrendered it, which means
Correct.
you can't ever get it again.
I believe there's some sort of an appeal process for the revocation, but I have no interest in it. So
Okay,
you're
so
correct. In future proceedings, no, I do not, but
okay.
I would like to continue my appeal for termination.
Anything else?
That's it, sir.
Any other questions from any other commissioners? Okay. Do we have potential? I'm sure we do for executive session. We'll entertain a motion to go into executive session
So
to
move, Mr. Chair.
discuss the allegations of misconduct. I gotta put that on the record. It's been moved and seconded.
Thank you.
Welcome.
We need a roll call vote.
Brian Crawford,
Yes.
Mark Poe,
Yes.
Monty
Abstain.
Montemaclo, abstain. Renell Neville,
Yes.
Tony Paree,
Yes.
Jared Ricky,
Yes.
and Euless Simmons.
Yes. Okay, everybody knows that. huh?
We have 2 minutes.
Yeah.
Thanks.
session and come back into public session.
I'll move.
It's been moved.
Second.
Second, take a roll call vote, please.
Brian Crawford,
Yes.
Mark Cole,
Yes.
Monty Montalvo,
Abstain.
Vernell Neville,
Yes.
Tony Puri,
Yes.
Eula Simeon,
Yes.
and Jared Ricky.
Yes.
Okay, the ayes have it. We're back in public session. Do we have any motions?
Mr. Chairman, I'm going to make a motion to reject LSP's motion for summary disposition in the matter of Kasha Dominique. And that's docket number 21-250T, and affirm that the hearing date be continued for October the 12th at 9 a.m.
Not be continued,
Or-
that it
or be-
is.
Yeah, to be set.
Okay, because it's already been said.
Yes.
You,
There you go.
have I been mispronouncing your name or,
Keisha,
no, the last name?
Domain.
Domain, okay. Okay, good. Because I'm terrible with names.
In North Louisiana, it's pronounced different, so
That's why we disowned them, but anyway.
Oh,
the fight goes on.
So it's been moved.
Mr. Chairman, may I address the council? Kind of just told me that he's not going to be available on that day.
I'll be out of state on official department business.
It's been set for months. I don't know what to tell you.
I mean,
We had a pre-hearing conference and
Oh, that was before my time.
on March, this was set on March the 9th.
okay. I mean, file a motion.
Yeah. I'll do that. That was by Jason Hesse.
Yeah, no, that's
That was way
understandable.
before.
Is the colonel's testimony gonna be necessary? I mean, you don't have to make that call right now. Y'all discuss that and make a call on whether or not.
And right now our docket is full through June. And I think it's going to be through July as of next week.
So, I mean, that's certainly y'all discuss that and make your call on it. If you desire a continuance, you can file one. We can consider it at that point. Okay, Ms. Domain, I'm gonna take a second to go through this because I know we haven't voted on it yet. I just want her to understand the motion before we vote.
Okay.
We have not voted, but what the motion is, it's not to say that you win this case. The motion is simply to say, at this point, the commission is not in a position to make a decision. That's what the motion
Yes,
is.
sir. I understand.
If we still currently have the hearing set for next month, that may be subject to a request for a continuance, which we will have to determine whether we would continue it or not at that point, but this is not the final resolution of the case, okay?
Yes, sir.
All right. Any discussion? Okay, take a roll call vote.
Is there a second?
There was a second, I thought.
A second.
Well, there is now for sure.
Brian Crawford,
Yes.
Mark Cole,
Yes.
Monty Montalvo,
Abstain.
Tony Puri,
Yes.
Jared Ricky.
Yes.
And Eula Simeon.
In light of the unanimous, I'm not going to vote. Okay, that takes us to the next item. Just make sure unless you hear otherwise, make sure you're here on next time because your case got close to being dismissed because of our inability to have had you here previously. So if you don't want that to happen, make sure you're here next time this matter comes up.
Yes, sir.
All right.
So, Ms. Domingue, right now it's set for October the 12th, 9 o'clock. If that changes, we will have a conference call. So you may receive a phone call from me, be looking for that if there's a change of that date. And then we'll have a conference to pick a new date if that's the case.
Yes, ma'am.
I would say whether you take that call or not, the ruling of the commission will be the ruling of the commission. So if we say it's changed, then, it's your responsibility to answer Ms. Feeney's call.
Yes,
Okay.
sir. I've been in contact with Ms.
Yeah.
Feeney. since-
Okay, well, good. I'm glad we got that worked out.
So that's over.
Okay, we'll move to oral arguments on pre-hearing motions filed in the matter of Daniel Fontenot, Department of Public Safety and Corrections, Office of State Police, docket number 22-260S. Michael Antune, representing Mr. Fontenot, George Hardy representing the Office of State Police.
Morning, Your Honor. Michael Antone for Mr. Fontenot.
Okay, is Mr. Fontenot also present?
He's not. We'll waive his presence.
George Hardy for Department of Public Safety, Office of State Police.
Thank you. So we have more than one motion, do we not?
Yes, we have a motion to compel that was filed by Mr. Antoon, and we have a motion to quash subpoena requests filed by LSP.
Which was filed? first?
LSP filed first, I think.
Well, and we take them in the order of filing then. Proceed.
Madam Referee, before I begin, I have copies of the subpoena requests. Should I provide them to?
And Mr. Hardy, I don't know if it's anybody else, but I'm having a hard time hearing you. If you
Oh,
don't
I'm
mind,
sorry.
speak up a little bit.
We have copies of all the subpoena requests for everybody. But if they're already, I'm just asking if they're in your folders. They're in the fold. They have them in their folders,
Excellent.
right?
Madam Referee, Mr. Chairman, distinguished commissioners, the express cause for the disciplinary action in this case is simple. Daniel Fontenot is disciplined for intentionally recording a conversation with a fellow trooper using his body worn camera in violation of LSP policies, which expressly prohibit the use of body worn cameras or other devices to record communications with other employees. The facts that LSP intends to offer in support of the disciplinary decision are wholly undisputed. Nevertheless, Daniel Fontenot is requesting that this commission issue no less than 22 witness subpoenas and 18 subpoenas ducis tecum in an attempt to mount an elaborate defense, ultimately claiming that Trooper Fontenot was somehow justified in recording his fellow trooper because he was worried that the trooper might misrepresent their conversation. Surely, if this concern were a valid defense, the prohibitions against recording fellow employees would not even exist. Louisiana State Police Commission Rule 13.11O provides that the commission or referee may limit oral argument to one or more issues. We are asking that this commission dramatically limit the scope of argument in this case to factual matters relevant to the alleged policy violations. In other words, all that matters here is whether Trooper Fontenot used his body worn camera to record his communications with another trooper outside the scope of his official duties. These are the only facts relevant to this case under the Louisiana Code of Evidence.
Is it the state police position that justification is not an appropriate defense?
That is our position. The principal guidelines for determining the scope of relevant evidence and witness testimony are found in Code of Evidence, Article 401 and 602. Article 401 addresses the bounds of relevance in general, defining relevant evidence as evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence.
Even if I were to agree with you, and that's an even if, so I'm not saying I do or I don't, even if I were to agree with you that justification is not a defense to the imposition of discipline, would it not be a relevant factor to determining the appropriateness of the amount of discipline?
Mr. Chairman, we do not believe so. There is the scope of discretion that is allowed in the use of body worn cameras is a general statement. The prohibition against using a body worn camera to record another trooper is specific and very clear.
Right. Let's just say, if I agree with you on that, the justification cannot be a defense, and I haven't prejudged that, but if I were to agree with you, let's talk to me about why it's not a relevant consideration for evaluating the propriety of the extent of the discipline that was imposed.
I believe that in this case, sir, the only thing that would matter would be whether Trooper Fontenot had any belief, whether justified, unjustified, reasonable or not. If he held a belief that it was necessary, then I believe the commission could take that into account. However, getting into specifics of why in the particular manner in which Trooper Fontenot intends to do, it will involve an attack upon his fellow trooper's character.
That's a different question that I would get to a little later. but do you at least concede that to some extent, perceived justification may be relevant to the extent of the discipline, and how far that goes is a question to be answered later.
I believe that's for the commission to decide and probably,
Okay,
outside the scope of my duty.
all right, fair enough. Now, I would like you to focus more instead on the extent of the subpoenas and whether or not the other troopers' past performances, unrelated to credibility, unrelated to things that one might argue could justify this, why those other subpoenas would not be appropriate. Do you understand what I'm getting at?
I understand. And I was saying, reviewing the Code of Evidence articles, Article 602 deals with the question of who may testify, and it provides that a witness may not testify to a matter unless evidence introduced is sufficient to support a finding that he has personal knowledge of the matter. And even when evidence falls within a broadly defined scope of relevance, it can be excluded when its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay or waste of time. Now, the arc of Trooper Fontenot's expected argument has been set forth in his pleadings on the matter of summary judgment, and a review of the witness list indicates that Fontenot intends to mount a sort of cumulative attack on the character and performance of his fellow trooper, who was the subject of the recording, as well as the performance of her supervisors, Sergeants Haugen and Willis. These lines of inquiry are irrelevant. Most of Fontenot's proposed witnesses have no personal knowledge of the matter at hand, namely whether Trooper Fontenot used his body-worn camera to intentionally record his communications with another trooper. So these witnesses should be barred from testifying in accordance with Code of Evidence Article 602. Furthermore, their testimony will not tend to prove or disprove any of the factual findings relied upon in the letter of discipline, which forms the basis of the disciplinary action, and should therefore be barred in accordance with Code of Evidence Article 401. All other remaining questions are questions of law, which may be settled without requiring this commission to conduct a full hearing on the character, moral fitness, or performance of any other employee of Louisiana State Police. And allowing these subpoenas to issue would certainly risk prejudice, confusion, and delay, and should therefore be barred under Code of Evidence Article 403.
Let's talk about the issue of, okay, let's put aside the question of the witnesses who are being subpoenaed to talk about her general past performance as a trooper. But aren't there some witnesses who are being subpoenaed who are being proposed to testify about her credibility, her vindictiveness, or whether or not she would misconstrue what this conversation and report something differently than what the conversation really was? I'm not talking about the performance witnesses. I'm talking about those character witnesses who maybe testify relative to facts that may have made the trooper believe that he needed something so that he didn't get thrown under the bus improperly.
It's certainly an argument that I would intend to address. I think that, frankly, I think it's a poor argument. Why not have a conversation with a human witness at hand? I think that's the most obvious way to do it instead of surreptitiously recording your fellow trooper. And there's also the issue of, whether recording a trooper is the policy behind the rule itself is simply that doing things like that, surreptitiously recording another trooper, another employee, it fosters distrust, it's bad for morale, things like that. Now, whether those sorts of witnesses are relevant, I would say absolutely not. The only question here is whether there was a recording of a fellow trooper using the body-worn camera within the scope of official duties. And I understand your point that the commission may want to consider whether the suspension is suitable considering the violation based upon other factors. However, I do think that there has to be a hard line drawn here if we're going to prevent prejudice, delay, and confusion of the issues. And that's sort of our position, is that this is the clearest place to draw it.
So though technically there might be some relevance, you think as a policy matter in the interpretation of those rules of evidence, that we ought to draw that line.
I don't see the relevance at all. And that is our position, is that it is wholly irrelevant.
Oh, okay, all right. You may proceed. I didn't mean to
Okay.
interrupt you.
That's all right. I appreciate it. As previously mentioned, Fontenot has submitted a request for the issuance of subpoenas to 22 people to appear and testify. And I believe, as I was told, you all have a copy of that list. LSP objects to all subpoenas to the extent that they have been requested in an attempt to make an issue of the personality, character, or performance of the trooper who was the subject of Fontenot's recording. Such subpoenas should not be issued, and any affidavits already filed relating to such issues should be stricken from the record and not considered by the commissioners in deciding this appeal. Additionally, LSP objects as follows to the subpoena requests. Witnesses 5 and 7 through 22 in the subpoena requests are purportedly going to testify about the trooper Fontenot recorded with regards to her work performance and not the facts relevant to the cause and the severity of the penalty. It should also be noted that witnesses 18 and 22 are no longer employees of Louisiana State Police. Request for witness 18 refers to opinions set forth in his affidavit. We contend that that request is vague. Furthermore, his testimony will not establish any facts related to the cause or severity of the penalty. And furthermore, if one must refer to an affidavit he executed to determine what he will testify to, his opinion relating to leadership in the military is irrelevant to this appeal. The subpoena should not be granted, and his affidavit should be stricken from the record and not considered by the commissioners in deciding this appeal. The subpoena request for witness 19, Dr. Wayne Steve Thompson, which refers to his opinions set forth in his affidavit, is also vague. His testimony will not establish any facts related to the cause or severity of the penalty. And furthermore, in referring to his affidavit he executed and intends to testify to, his opinion relating to Louisiana State Police policy and its application in this case are irrelevant. Dr. Thompson is not the appointing authority who is responsible for setting and enforcing Louisiana State Police policies and the conduct of its employees. We believe the subpoena should not be granted, and his affidavit should be stricken from the record and not considered by the commissioners. Subpoena request for witness 20, Alicia Pickens, is similarly vague. She is being called to testify to allegedly being recorded by an LSP supervisor without her knowledge. It's during some previous incident. The subpoena request is vague in that it doesn't identify the supervisor, the date of the alleged event, or any of the specifics of this event. More importantly, this and all similar testimony is irrelevant to the disciplinary action on appeal. Allowing this kind of testimony would create a hearing within hearing situation that will derail these proceedings in pursuit of a determination that is wholly irrelevant to the questions of law and fact on appeal. Moving on to the subpoenas ducis tecum. Fontenot has requested that subpoenas ducis tecum be issued for records that are not relevant to this appeal. I believe you also have a copy of that list. In particular, items number 2 through 10 and 16 of the request are records relating to the trooper who was the subject of the recording. Specifically, Fontenot has requested the following records: personnel records, applications for employment and hiring, evaluations, time and payroll records, complaints made against her, disciplinary actions, complaints made by her, including EEOC complaints, drug recognition and standardized field sobriety testing records, and records relating to a crash in which she was involved. Not only do these requests encompass confidential matter, they are in no way relevant to the disciplinary action that forms the basis of this appeal. The commission should not allow Trooper Fontenot to turn this appeal into a trial of the person who is the subject of his impermissible recording, especially when the fact of the recording is not in dispute. The requested subpoenas ducis tecum for these items should not be granted. We further contend that item 11 should be denied as impermissibly vague. Item 15 of the request is also unreasonably vague. And furthermore, in addition to vagueness, we object to the request for production of any records relating to any pending IA investigation to protect the integrity of such investigations. Item 17 should be denied as irrelevant. Sergeant Willis's performance as a supervisor is not on trial and has no bearing in this matter. Item 18 requests documents that were the subject of a previous subpoena ducis tecum, which was denied. And those documents are also irrelevant, and the request should be denied again. Just to summarize, it's our position that this case is very simple. Trooper Fontenot has never denied that he made this recording, and he made it without his fellow troopers' consent. We believe that the policy is very clear on the prohibition against recording fellow troopers outside the scope of your official duties. And from what I gather from the proposed defense that's to be put forward, those issues or the issues brought up by the defense can be wholly dealt with as matters of law. They have to do with interpretation of the policies. And it does not require 22 witnesses to come in here and put another trooper on trial and potentially damage her character and confuse the issues that are properly before the commission. Thank you.
Questions from any other commissions? Mr. Toon.
Mr. Chairman and ladies and gentlemen of the commission, I'm not sure where to begin.
I'll give you this question to start with.
Sure.
What is this, a trooper's past performance in her other jobs have to do with anything relevant to this case, unless it relates to maybe complaints that she made against co-employees or things along those lines? What does that have to do with what we're dealing with?
I can answer that easily, but I think I have to answer that. I have got to back up a little bit.
I thought you didn't know where to start, so I'm giving you a starting point. But go ahead.
Got you. Well, I'm going to start a little bit before the starting line, if you're all right with it, sir. We can't start with a presumption that by recording the conversation, it's an automatic violation of the body worn camera policy, because a plain reading of the policy shows it's not. It just isn't. It isn't written that way. There's no blanket prohibition.
We don't need those witnesses to read the policy. We can read the policy and tell you, either agree with you or disagree. We don't need those witnesses to tell us that. So tell me why the witnesses about her past performance, unrelated to things like making false statements about another employee, why would any of that be relevant to what we got to decide?
Because in the body worn camera policy, it does allow a trooper to utilize the body worn camera to document incidents that he believes it would be appropriate and valuable to document. Incidents is not defined. It's a broad term. As long as the camera is used in the course and scope of his duties, concerning his official duties, I believe are the exact words in policy. You can use a body worn camera. According to the body worn camera policy, it says this policy is not intended to spell out every single situation in which a trooper is able to use his camera. And I'm paraphrasing. I don't have it handy in this book, but I mean, it's in here. But in any event, there are some exceptions that leave the door open for a trooper to exercise discretion when he thinks it's appropriate and valuable. So now we have to crawl inside of his head and find out why he would think it appropriate and valuable.
So why is her past performance appropriate to this consideration?
Well, if we're talking about performance, I can only surmise, and I can't crawl in all of your heads, but I have a feeling that when everybody deliberates, if you feel like this is a one-off where a trooper was picking on another trooper and didn't have a legitimate reason to really pull her to the side and counsel her about her performance, then you'd be a little swayed against him. However, if you understood that there was a history and pattern of deficient performance that was affecting the morale of the troop, that other officers had come to him as a master trooper, other younger officers, and complained that he went to his superiors, they refused to address it. He was given authority to address it. He did. But to protect himself in that moment from any frivolous allegations that might occur later, which is, another separate issue, which has to do with that. then he chose
For the
to,
sake of your arguments, I'll give you that one right now, but I want to
Sure.
hear about her past performance and how that could be a justification.
well, it goes to why he would feel it, well, it goes to why he would even encounter her in the first place, because there's also a conduct unbecoming charge before the commission. And it's kind of hard to decode, but it looks like the conduct unbecoming is a broad category. You all know that. It encompasses a lot of behavior. And it looks like from the disciplinary letter and from the summary of the investigative findings by IA that it's kind of based on a hybrid of A, him recording her, and B, him affecting her morale in some way by picking on her more or less. But if he actually has a legitimate reason, because there is a history of performance issues as documented and testified to by other troopers, perhaps documented in all these files I'm asking for,
On
then
some of the
that's,
files, even when she was working at other police agencies,
well,
some of the things you're asking for, some of the witnesses you want to testify.
well, and I can answer that too, sir. Lake Charles is not a big place.
You're up there. I'm very familiar with it.
Well, then you know. A lot of the.
My little town, but go ahead.
You know, well, then a lot of the officers know each other. A lot of them participate in field sobriety training together with different departments. One of the affidavits I presented was from a former LCPD officer who was Trooper Robertson's FTO, who disclosed to Trooper Fontenot over time, look, I've seen this before too, man. I know, I've dealt with it. So there's a pattern here that was within his knowledge. It continued into LSP. He decided to address it on this particular date, and to cover himself and the department, he just hit record. There's nothing inappropriate in the conversation. Nothing has been alleged to be inappropriate about it. It's just to cover his backside move. And he was right to do so, because after the fact, we see later that she did file EEOC complaints that, to my knowledge, there's been no action taken on against any of the people referenced therein. So
That doesn't necessarily mean they weren't well founded, though.
I understand that, but regardless, it shows that propensity to do what he was concerned might occur. In any event, all of it, the past performance issues speak to the reason he needed to address her in that moment, which speaks to the conduct unbecoming. He wasn't picking on her. It was necessary under the master trooper job description on the commission website. A master trooper can exercise functional superiority over less senior troopers. I have an affidavit from a former sergeant, first line supervisor, that says a master trooper's job is to handle these things before it gets to a sergeant. Trooper Fontenot did try to go. Master Trooper Fontenot did try to go to his sergeant. They elected not to get involved and said, y'all handle it yourselves, which to me is a tacit authority to go deal with it. He did. And here we are. The policy says what it says. We can argue that legal argument all day. I don't want to devolve into that. But
Because I don't think it's relevant to this
sure.
issue.
And then he chose to record because of his concerns based on what he knew about her credibility. This is not improper character evidence, by the way. Code of Evidence 404, the bar against character evidence applies if I'm trying to use past conduct to prove that she acted in conformity therewith on a particular occasion. Most of you.
The argument is that you can use it for his state of mind. It justifies. We got that.
Understood.
But some of your subpoenas are pretty broad. They want her entire basic personnel file to show all of her past conduct, some of which has nothing to do with what his state of mind might have been.
It certainly would have informed. I just disagree with that. When you work in a small town, when you know the officer she's worked with in years past, when the chief of police tells you in a restaurant that that's one of the only officers, if not the only officer, that he said is not eligible for rehire if she ever comes asking for a job back, that plants something in here. And that informs your decision making moving forward.
Personnel file.
It actually is, sir. I got it by a public records request, and that's noted on the page, but I'd like to subpoena it so that it's official. I apologize, but that is noted in the file that she's not eligible for rehire. So in any event,
What about the request for a witness to talk about a prior recording by a supervisor? Have you alleged discrimination as part of the basis for your appeal?
No, sir.
So whether or not this other person did the right thing or didn't do the right thing and wasn't penalized for doing the wrong thing, if it were the wrong thing, what does that have to do with what we got to decide for your client?
Well, with some of the subpoena requests with respect to, whether or not action was taken and to what extent action was taken with regard to other alleged or confirmed misconduct in other cases, that's kind of a broad category, but
If you have not alleged discrimination, whether action was taken against others who may have been engaged in the same wrongful conduct, I'm not prejudging it was wrongful, just to make the point, whether action was taken against others who engaged in the same allegedly wrongful conduct is not really relevant to our consideration unless we were to be considering a claim of discrimination, as I see it. So tell me why I'm wrong.
okay. Well, as you noted earlier, sir, we're not just here to talk about the cause, but also the severity of the punishment. And under PO 211 K3-4, the severity is based in part on mitigating factors, including but not limited to, and I'm skipping some, similar action taken with respect to similar conduct by other employees. So in situations where other
Another employee was not punished at all, there's no way for us to compare the action, the severity of one punishment that never took place against the severity of his punishment. I mean, there's no comparison to be made.
Well, I would disagree. If another employee testifies that they were recorded without their consent and no punishment occurred, then that speaks for itself. In this case, my client recorded another employee and he's been punished. That it's clearly inconsistent. And then there's cases where officers don't use their body cam when they should, which in my opinion is way worse than actually using it in an innocuous situation and no punishment is levied. So I would say that's wholly inconsistent.
I feel very strongly about troopers using their body cams when they're supposed to. So I'm not endorsing any of that, but I'm still not following your argument on if somebody got a favor and didn't get punished for something, how can I compare that? And you don't have an alleged discrimination claim. I don't see where that's relevant for a comparison purpose.
I can only reference 211 K3, sir, that in determining the severity, we look at action taken with respect to similar conduct by other employees. I interpret that as action not taken as well. That's how I
All right.
believe it's relevant.
I understand your argument.
Thank you.
Anything else?
Sir, I think we've covered categorically the gamut. I need to be able to show this commission what my client, why he felt the need to counsel this trooper, so that you can see it was legitimate. His concerns were legitimate. At least one other witness interviewed by IA mentioned no hearing about some of these other issues, although it's hearsay, but that shows some grumbling. But I want to put some other witnesses on that actually know firsthand. He wants to, I think the words were dramatically limit the testimony. I'm entitled to a full and fair hearing, and I understand the commission can limit testimony under the commission rules, chapter 13, but not eliminate. There's a big difference. He's got to be able to tell his story. He's got a property right in his employment, a due process right, and that requires an opportunity to be heard, compulsory process to call witnesses, to get documents that help him tell that story. So I have to be able to show why he did what he did, and then I have to be able to show why he felt it appropriate and valuable to hit that button for just a few minutes. And nobody said he did anything wrong during that conversation. We're not here because he did something wrong during it. He wouldn't have recorded himself if he intended to do something wrong during it. He recorded it so that nobody else could say he did anything wrong, and he didn't. And so with that, I would just ask the commission to give my client a fair shot at the hearing.
Any of the other commissioners have any questions?
I rest, sir.
You can take a very brief rebuttal
Very
time
brief.
if you would like.
Very briefly, thank you. I think that we would be willing to stipulate to Trooper Fontenot's state of mind. If he believed that it was necessary Okay, we can stipulate to the fact that he's a great guy and he's a good trooper. We can stipulate to that as well. What we're talking about is this one event. And we are not saying, the violation itself is the recording. It's not innocuous. It is recording a fellow trooper is in and of itself. The reason the policy exists is because it creates mistrust among the troops. It is a bad practice. You don't want to have troopers recording each other surreptitiously with their body worn cameras. You don't, it's not a good, it's bad for morale. I think that, saying that we want to dramatically limit the scope of testimony here, of course, it's going to be dramatically limited because there are subpoenas being issued, requested for 22 witnesses. Most of these witnesses, as I said, they're called to offer irrelevant testimony. And so, when I say dramatically limit, I'm talking in a mathematical sense, not necessarily in a substantive sense. But it is our position still that anything regarding the character or the performance of the trooper he recorded, and it remains completely and wholly irrelevant. And the prohibition there is, we've introduced the idea that there is a statement affording troopers some discretion in what to record with their body worn cameras. It's understood. But as I said, the specific law abrogates the general law. The specific law is a specific prohibition against recording your fellow trooper with your body worn camera. That is the way that the law should work.
Relative to the interpretation of the policy, I think this commission is appropriately composed. We can interpret it, but the question more turns, and we're going to give the interpretation that we believe is the appropriate one, but the question turns on the scope of this testimony. So, all right. Anything else?
No, I appreciate it.
All right. Any other questions? Yeah. Okay.
Want to proceed to the motion to compel and then have one?
Yeah, please.
Yeah. So next we have a motion to compel that was filed by Mr. Antoon.
Correct. And I believe this is moot. Mr. Hardy, you can correct me if I'm wrong, and it's actually a pleasure to meet you, by the way. But I believe most, if not all of these materials have been provided.
We've given you everything we have.
Okay. I was given these materials on Tuesday to give you some context. I was at federal court yesterday morning, some other things. I've reviewed them as closely as I can. I believe this motion has been satisfied. I would be happy to withdraw it as long as I can do so without prejudice, just in case something is missing.
When is this set for hearing?
It's not, because it really was set for this month and
Oh,
Mr.
okay.
Antoon required a continuance because he had another.
Okay.
event.
So,
As our advisor, would it be appropriate to allow him to withdraw it without prejudice?
I don't have a problem with that since we have time to.
yeah, I'm inclined.
And just a note, you filed the motion to compel before the documents were due. You go by our pre-hearing conference order. So the documents were actually due on September the 7th from LSP, and you filed the motion to compel on July 13th.
Sorry, it's
So
been
it's
going
just
on
something
about
to,
2.5 years.
yeah,
So
so.
I guess I got antsy.
All right.
Thank you. Yeah, I'll withdraw, Your Honor.
Okay. Well, with that, I'll entertain a motion to go into executive session to discuss allegations of misconduct. Been moved and seconded. Take a roll call vote, please.
Brian Crawford,
Yes.
Mark Cole,
Yes.
Monty Matalago,
Yes.
Renell Neville,
Yes.
Tony Puri,
Yes.
Jared Ricky,
Yes.
and Willie Simeon.
Yes.
Yes.
Monty Montalvo,
Yes.
Cornell Neville,
Yes.
Tony Puri,
Yes.
Euless Simeon.
Yes.
Jared Ricky.
Yes.
Okay, the motion passes. We're back in public session. And Mr. Ward, I have a question for you, and I will give you the benefit.
Party?
Mr. Hardy, yes. Where did I get Ward from? Anyway, Mr. Hardy. No wonder he looked at me like.
I mean, there's mispronunciations.
Then they're just completely screwing it up. Mr. Hardy, and I will give you the opportunity to step out with the colonel before you respond to the question that I'm going to ask of you. Would the state police have any opposition to the commission reserving its position on the legal point, but would it have any opposition to the commission making a finding that in this particular case, the Mr. Trooper Fontenot had a reasonable belief that the recording was necessary to protect himself from improper conduct or retaliation by the person being recorded for the purposes of the upcoming hearing? And y'all can take a minute to go talk about that.
this point, at this time, our position is that we cannot know Trooper Fontenot's state of mind at the time he made the recording. We are willing to stipulate to his state of mind, his offered state of mind that he believed it to be necessary to record. However, we are not willing to stipulate that that belief was reasonable.
You earlier made a statement, I should have given you both of this before I let you out to powwow. You earlier made a statement that it was not the contention of state police that having the meeting was improper, or that anything improper happened during the meeting other than the recording. Are you in a position to continue with that? Because I don't want to make assumptions based on statements that were made during an argument.
Correct. I think that part of this depends upon, it does relate to Trooper Fontenot's state of mind. If he believed it to be a dangerous or precarious conversation in any way, then we do believe that it was ill-advised, at least in the manner that it was taken. There were other alternative means or scenarios that he could have devised for approaching a fellow trooper about criticizing their performance. Most obviously doing it in the presence of someone else. So I think that, that's sort of our understanding. I don't think we're willing to completely forego any criticism of the manner in which, or his choice to hold that conversation in that manner. So at this time.
And by in that manner, you mean broader than simply because it was recorded. You meant the manner in which it was conducted.
Correct.
We'll need to go through.
All right. Well,
All right.
number 6.
I'll move on behalf of this was not requested by state troopers, but I would move that the commission on its own strike witness number 6 on the list of subpoenas as not being relevant to the proceeding. Do I have a second?
Not naming the witnesses.
I'm
as-
sorry.
As not naming the witnesses.
Yeah.
And may I ask, Mr. Chairman, should I reserve our objections until the end per item, or would you rather line item go through them?
This is not, this is the findings of the commission. It's not our argument by you at all at this point.
Yeah, no, I understand that.
Is there any discussion by the commissioners on witness number 6 on the subpoena list? All in favor?
Aye.
Any opposed? The ayes have it.
Who was this?
Okay, relative to the other witnesses, in light of our failure to reach an agreement on what the facts would be as we proceed, I think we need to go through each of them other than the ones that have not been objected to.
So what, how about if I read the number and the name of the witness, and the commissioners look at what it says that person is proposed to testify about, and then you can make a motion about whether to strike or to keep.
Which tab are we on?
We're talking,
Tab two.
tab 2,
Tab 2.
and it's, yeah,
I'm sorry.
tab 4, number 2. Ready? Okay, so beginning with witness number 5, Lieutenant Jonathan Odom. The commissioners are to read the comments and then to either make a motion to strike the witness, to grant the request to strike this witness, or to deny the request to strike this witness.
Chair,
Yes, Commissioner Crawford.
I make a motion to strike this witness.
Do we have a second?
Second.
Been moved and seconded. Any discussion from the commissioners? All in favor?
Aye.
Any opposed? The ayes have it.
Moving on to witness number 7, Sergeant Chris Hill.
Chair.
Commissioner Crawford.
Make a mission to deny the appellant request and strike this witness as well.
Wait. You're granting the appellee's
I'm sorry.
motion to
Motion
quash.
to quash. And striking this witness.
And do we have a second?
Second.
Okay. Any discussion? All in favor?
Aye.
Any opposed? The ayes have it. And let me just make a point of clarification. There's been some discussion about striking affidavits. In the hearing, the commission does not consider affidavits. We consider live testimony and not affidavits. So we're not going to address the question of striking the affidavits, but it is not competent evidence at the hearing.
Now, witness number 8, Master Trooper Andrew Leonards.
Mr. Chair,
Yes, Commissioner Crawford.
see if I can get this straight. Grant appellee's request to quash and strike witness number 8.
Do I have a second? Any discussion? All in favor?
Aye.
Any opposed?
Move to number 9, the 9th witness, Trooper Matthew Gaspard.
Mr. Chair,
Commissioner Crawford.
make a motion to grant appellee's request to quash and strike witness number 9.
Do I have a second?
Second.
Been moved and second. Any discussion? All in favor?
Aye.
Any opposed? The ayes have it.
Witness number 10, Officer Greg Marchand.
Chair,
Commissioner Crawford.
make a motion to grant the appellee's request to quash and strike witness number 10.
Do we have a second?
Second.
Any discussion? All in favor?
Aye.
Any opposed? The ayes have it.
Witness number 11, Byron Sam.
I would move to deny the motion. Do I have a second?
Sorry.
It's been moved and seconded. Any discussion? All in favor?
Aye.
Any opposed?
Next
The
witness,
motion to strike number 11 is denied.
witness number 12, Sergeant Lyle Robertson.
Mr. Chair,
Commissioner Crawford.
make a motion to grant the appellee's request to quash and strike witness number 12.
Second.
Any discussion? All in favor?
Aye.
Any opposed? Aye. The ayes, those in favor prevailed. The motion to quash as to witness 12 is granted.
Witness number 13, Sergeant Jared David or David.
Mr. Chair,
Commissioner Crawford.
make a motion to grant appellee's request to quash, strike witness number 13.
Do I have a second?
Second.
Been moved and seconded. Any discussion? All in favor?
Aye.
Any opposed? The ayes have it.
Witness 14, Sergeant Julia Amanda Willis.
Mr. Chair,
Commissioner Crawford.
make a motion to grant the appellee's request to quash and strike witness 14.
Do I have a second?
Second.
Moved and seconded. Any discussion? All in favor?
Aye.
Any opposed? The ayes have it.
Witness number 15, Lieutenant Joey Attaway.
Mr. Chair,
Commissioner Crawford.
make a motion to grant the appellee's request to quash and strike witness 15.
Do we have a second?
Second.
Moved and seconded. Any discussion? All in favor?
Aye.
Any opposed? The ayes have it.
Witness 16, Sergeant Wilbert Poncho.
Mr. Chair,
Commissioner Crawford.
Make a motion to grant the appellee's request to quash and strike witness 16.
Second.
Been moved and seconded. Excuse me. Any discussion? All in favor?
Aye.
Any opposed? The ayes have it.
Witness number 17, Sergeant Messina, Sal Messina.
Mr. Chair,
Commissioner Crawford.
make a motion to grant the appellee's request to quash and strike witness 17.
Second. Second.
Second.
Been moved and seconded. All in favor?
Aye.
Any opposed? The ayes have it.
Witness number 18, Captain Kelly Mazzelli, or something like that.
Something. Mr. Chair,
Yes, Commissioner Crawford.
make a motion to grant the appellee's request to quash and strike witness 18.
Do we have a second? Second. We have a motion and a second. Any discussion? Any discussion? None. All in favor?
Aye.
Any opposed? The ayes have it.
Witness number 19, Dr. Wayne Steve Thompson.
Mr. Chair,
Commissioner Crawford.
make a motion to grant appellee's request to quash and strike witness 19.
I second the motion. Any discussion? All in favor?
Aye.
Any opposed? The ayes have it.
Witness number 20, Alicia Pickens.
Mr. Chair,
Commissioner Crawford.
make a motion to grant the appellee's request to quash and strike witness 20.
Second.
It's moved and seconded. Any discussion? All in favor?
Aye.
Any opposed? The ayes have it.
Witness number 21, Lieutenant Kevin Kirkham.
Mr. Chair,
Commissioner Crawford.
make a motion to grant the appellee's request to quash and strike witness 21.
Second.
Moved and seconded. Any discussion? All in favor?
Aye.
Any opposed? The ayes have it.
Witness number 22, Captain Michael Ross McCain.
Mr. Chair,
Commissioner Crawford.
make a motion to grant the appellee's request to quash and strike witness 22.
Moved. Do we have a second? Any discussion? All in favor?
Aye.
The ayes have it. Any opposed? The ayes have it.
And now we will move to the request for subpoena ducis tecum.
So I do have a question about number 15. Has number 15 been satisfied by the production of the?
We're on the Deuces Tecum, sir?
Yes.
Mr. Chairman, as I previously stated, I believe that has been satisfied.
You're not warranting it, you're reserving your rights, but we don't need
believe
to
it has.
address it today.
I believe it's been satisfied.
Okay. And you reserved your rights to us to bring that later, but we don't need to address it today.
I would concur with that. Thank you, sir.
Thank you.
Ready to move to the subpoena ducis tecum?
Yep. Yeah.
Okay, beginning with the request number 2. Personnel file and employment records of Trooper Summer Robertson.
Mr. Chairman,
Commissioner Crawford.
can I make a motion or entertain a motion that we do these collectively together from 2 to 16 on the document request?
2 to 10 and then 16 and 16.
Yeah, 2 to 10 and then 6.
2 to 11.
Well, 11 was a different thing.
2 to 10 and then
Well, actually,
I'm just
are
asking.
you trying to group them according to the basis for the denial? Or do you just want to go through all the numbers that you want to do at one time? I mean, is it, if they're different bases for your
Yeah, I mean,
decision?
I think if it's proper, we can say 2 through 10 and 16.
Okay,
That'd be correct?
right. There's other numbers within that you'll be addressing like 11, 15, 17, those are all part of the motion, and 18. But you want to lump those together separately first, 2 through 10 and 16 as one motion?
I
Which
do.
is fine.
I do.
Okay. 2 through 10 and 16. So do you need to have them read, or do you just want to review
No,
them
Give
yourself?
give us a few minutes to.
Give us a few minutes to
Okay.
review them.
I guess that would mean give us a few minutes. Okay, I'll give us a few minutes to review. Is everyone ready?
Yes.
Any discussion? All in favor of the motion? Say aye.
Aye.
Any opposed?
Is there a motion?
We didn't state a motion.
Yeah, you didn't say the
Chair.
motion.
No, I just asked the legal opinion that could we group these together?
I'm
into-
sorry.
So
Yeah.
if it so pleases the chair, I can make the motion at this time.
Go ahead.
So making a motion to grant the appellee's request to quash document requests 2 through 10 and number 16.
Do we have a second?
Second.
Moved and seconded. All in favor?
Aye.
Aye.
Any opposed?
You want me to move on to, okay.
Yes.
The next one is document number 11, subpoena Deuces Tecum request number 11.
Mr. Chair,
Commissioner Crawford.
I make a motion to grant the appellee's request to quash document number 11.
Do we have a second? Any discussion? All in favor?
Aye.
The next document number is number 17.
Mr. Chair,
Commissioner Crawford.
make a motion to grant appellee's request to quash document request 17.
Been moved and second. Any discussion? All in favor?
Aye.
Aye.
Any opposed? I oppose.
And then the last request is number 18.
I move to quash. I move to grant the motion to quash that request. As being irrelevant to these proceedings. Any discussion? All in favor?
Aye.
That concludes all of the motion to quash.
It's a matter that we will have a formal written opinion on, or is Let's just end it.
I think so. I think.
If it's the appropriate time, Mr. Chairman, I would like to lodge an objection to these, if I may, sir.
Objection noted.
Uh,
As to all of them, it's noted.
okay, I just didn't know if I need to go into specifics. Okay.
That concludes this particular matter. We move on to the next item. It's the director's report.
Mr. Chairman, it's a very brief report. If you look behind tab number 5, you'll see the commission's expenditures since last we met. Questions regarding the commission's expenditures? We're coming up on budget season very, very shortly.
It rolls around that way.
Yes, it does every year. The next meeting of the commission is scheduled for October 12th at 9 a.m., where we are currently scheduled to hear the matter of Kasha Domain, docket number 21250-T. And the only other item I have is to advise that the annual training reminders will be coming up soon that are due by the end of the year. It's already that year time again as well. And
It was kind of early, aren't you?
I'm gonna get on them early, see if we can knock those out. That'll be the ethics and preventing sexual harassment training required for commissioners. And actually lastly is that we are working on the dates for the fall promotional exam opportunity. And we will be putting out an announcement very soon about those dates. That concludes my report.
Did we have any requests to address the commission by employees or others on matters not on the agenda?
We did not, Mr. Chairman.
No. Entertain a request to adjourn.
Move.
Any opposition? Seeing none, we are adjourned.